Hello students, welcome to my course on Constitutional Law Online. I'm Lawrence Likar. I'm the chair and a professor in the Department of Justice, Law, and Security at La Roche College. This is new. What I'm in the process of doing is having a tape lecture for each of your sessions. This is the first one. And what we're going to do is I'm going to furnish an overview to you of the course itself, some of the key principles that you should be paying attention to while you go through the course. And I'm also going to talk about some of the fundamental, the foundational elements of the U.S. Constitution. You know, why did we create it? Why was it created in the way that it is? What was it designed to do for our nation? We'll start out, though, with the course you should have access to your outline. It's found on Blackboard, and the outline itself is going to serve as kind of, again, your foundation document for this course, including if you look at the schedule, the syllabus, I mean the schedule in the back, it lays out each day and what I actually expect of you in the course. The assignments are in here. Now there will be in the assignment section of Blackboard by week. I will furnish any additional assignments. Those will be in addition to what is already listed in this outline. Now, when we're examining this, make sure that you look at the objectives for the course. This is what you're going to be evaluated on, as to whether or not you met the objectives. And let's start with the first one, understanding how to research and brief a Supreme Court case. That's essential in this course. One of your requirements is going to be to actually brief 3 cases. And I know you're sitting there probably thinking now, well, what do you mean by brief a case? A brief is essentially a short exposition of an opinion of the Supreme Court that you write, capturing certain key ideas and also your evaluation of the reasoning of the court. And let's start the concept of briefing with the very idea of legal reasoning, because what you're looking at is how the court has reasoned to a decision. And it starts with any case that you look at, the first thing you're going to have to identify is the issue in the case. These cases are in your textbook, and the textbook is by Kanovitz. Now, you should have the 13th edition. This is the 12th, but the 13th edition. The 12th will actually suffice, except there may be a few cases that have been additions. I think there's been one change in the law, which I will point out during the course, but both editions can actually suffice. The cases are in the second part of the course, and they're very edited cases of actual Supreme Court opinions. They're severely edited, actually. Some of these Supreme Court opinions are 10 times longer. But in this case, they're designed for students in college. And when I say brief a case, it basically means you're going to read the case and you're going to look for a series of factors in the case that will enable you to remember it. And when you're faced with similar fact circumstances, to apply the reasoning of the Supreme Court in the cases that you briefed to an exam question that I will give you, giving you similar facts and seeing whether or not you can reason through what the correct decision would be. So, these are the cases, second half of the book. You're expected in this course to read the text itself, which is the first half and pretty hard to read, and then brief on your own, not to be turned in, but a very shortened form of briefing these cases. And again, if you don't do them at all, that's up to you. I'm basically giving this the first form of briefing that we're going to talk about is mainly for your own benefit. The briefs that you're going to have to do, which there are just 3, will be on cases that I assign to you. They will not be cases in the book. The cases will be much longer, and I'm really looking at how well you reason and how well you write on the 3 briefs that I assign for the course. Those will be due the last day, the last week of the class. Those briefs will have a fairly much more elaborate briefing format, which I'll explain really more in the probably in the second class. But in the meantime, for the first form of how you look at a case, how you brief that case, we're going to go through the basic formula of legal reasoning that most lawyers use and judges use. And that's called the Irack Formula. And Irack stands for, we'll put this up close here. Hopefully you see it. And Irack stands for issue. And the R is for the rules of law. The A is for apply it. You apply it to the facts of the case. And C is how the court reaches its conclusion and how you may be reaching a conclusion when I give you a certain set of facts. Irack is actually a fairly good way to reason in general. I mean, we look at the facts we're faced with. In this case, it's going to be the facts given to you in an opinion. And then we pick out what are the key facts, and then we look at the issues the facts present us with. In regard to judicial decisions, oftentimes the court will identify the decisions by saying the question before the court or the issue before the court. Sometimes they won't use that specific language, but after you review the facts, the issue will become apparent, sometimes apparent to you right away. So once your issue is identified, the next thing that you look for in the case that you're reading actually are the rules of law that the court is relying upon in reaching a decision. Those will be, in some cases, easy to pick out. In other cases, they may be difficult. But it's part of your reasoning process to be able to identify these basic legal rules or principles that the court is working with as it reaches a decision on the issue that's presented. In this course, all of these will be Supreme Court issues, so that every issue will involve some basic aspect of the U.S. Constitution that has been challenged or that has been violated. And then the legal principles that the court looks at, and then how it applies the appropriate legal principles to the facts of the case and reaches a conclusion as to whether or not the constitutional principles have been violated or they have not been. And the Irack Formula, it gives you a simple way of kind of honing down your edited case that you have and writing it out yourself so you understand it. In particular, you should make sure that you have the distinction down between the issue of the case. What's the issue? The issue could be something like a search of somebody that a police officer, the government. Remember, the Constitution in regard to many issues is all about the government violating our rights, the citizens' rights. So let's say it's a police officer who has arrested you or detained you for a traffic violation. And the issue might be whether or not the search, if there was a search that was conducted, or the stop, whether the stop itself violated the Constitution. Once that's done, once that issue is identified, then there are certain legal principles that are already in existence that might determine the answer to that particular issue. In other cases, it may not, but will help the court in reaching, by applying the legal principles to the facts. It might help the court reach its own conclusion. And that's basically the reasoning that the court will use. Sometimes the decisions are very easy, other times they're more difficult. The rules of law that the court works with have been developed in other cases involving similar fact situations, but every case is unique to some degree. And with the U.S. Constitution, when the Supreme Court decides a case, the rules of law the rule of law that it reaches, or the rules that it reaches that apply to that case, those laws are restricted in regard to the case, the facts that they're working with. It means that a decision that the Supreme Court reaches, those decisions are always limited by the facts of the case. The Supreme Court doesn't reach decisions in a specific case and says that this is going to apply in all cases that are close to these facts or slightly different. It would only apply to cases involving the facts before the court. So that's basically you basically are using the Irack principle to enable you to read the case. You make sure you know what the important facts are. You basically pick out the issue. You look at the rules of law that the court's using in the opinion that you're reading, and then you see how the court applies it and reach a conclusion. And this will help you in answering exam questions in this course, because the factual situations you will be given in an exam will be based on very similar facts circumstances to the cases you're reading. And when you identify those fact circumstances, the applicable rules of law should flash into your mind, and that should help you answer any exam questions. If you don't use this briefing process, you can get very confused on exams. You won't be quite sure what rules of law apply. It is possible to handle this course without briefing the cases in your book, but I've found that students who do that often get confused during the exams, and they lose the ability to link the applicable rules of law that they should be looking at or should be analyzing with the facts. So that the Irack principle, briefing the individual case, is a good idea. All right, back to your outline. I expect you to understand, for example, SL number 2, understand the historical events that led to the formulation and adoption of the U.S. Constitution. Now, on that topic itself, and we went through the briefing, when we look at the actual foundation or the formulation of the Constitution, remember that the Constitution really serves two major purposes. One, it is the structure of a government. It is the founders, the drafters of the Constitution, the delegates in formulating the Constitution were trying to design a system that would enable our government to function efficiently and ensuring that the citizens were secure, that they had liberty. The second portion of the Constitution are the amendments, specifically the first 10. They're often referred to as the Bill of Rights. Now, those principles were implemented subsequently to the actual original drafting of the Constitution. The Bill of Rights were designed as a protective measure for the citizens of the United States from what the drafters of the amendments thought was a potentially tyrannical form of government that could arise in the future. They were afraid of having their own government change into a government that would restrict their rights, just like the British government did prior to enduring our revolution. So you've got these two portions: one, a framework for the government of the United States, and secondly, protective measures to ensure that your liberties, your civil rights, are not violated by the U.S. government itself. Now, those are the two overreaching, broad ideas behind the Constitution. And let's look at, if we look at this, the history of it, it's a little different. It's not as clean cut as probably that I laid out. And if you, in your text, you have a copy of the Constitution. For this course, I expect you to really understand the articles, the 7 articles. And let me just briefly, let's explore these. And I'm going to just tell you a few things. These 7 articles are important in regard to how the drafters felt about the way our government should be structured. Let's start out with the idea that we, the people of the United States, in order to form a more perfect union. Remember, the reason they're saying in order to form a more perfect union was really a remark that referred to the fact what they were originally meeting for was to actually revise the Articles of Confederation. That's not what actually happened. They weren't revising the form of government they were currently working under. They actually ended up drafting an entirely new government. The old Articles of Confederation essentially treated the states as had complete sovereign rights. They were basically were equal to the national government, and the national government had relatively little power and served mainly in their relationships with foreign governments. And at the Constitutional Convention, which was called to revise the Articles, basically James Madison, Alexander Hamilton were probably the major players who really wanted to not just revise, but to create a whole new Constitution. Madison's idea was based on kind of like it's often called the Virginia Plan, but he had thought a lot about how the national government should be structured to be more effective and stronger. And obviously, Alexander Hamilton wanted a very strong federal government, and really more concerned with the power of the federal government than he was over states' rights at the time. That seems to be the consensus as to his viewpoint at the time, that he was instrumental in forming the government. Now, the 7 articles. Article 1 deals with the Congress, the legislative powers, and that is Article 1. And it's clear that the Congress has under the Constitution that the drafters wanted the Congress to have a great deal of power. That was the main article. The Congress is involved in just about every power of the president, in which are the 2 out of the 3-part branches. They were looking at the presidency, they're looking at the Congress, and looking at the Supreme Court, the court itself. These tripartite form of government, this checks and balances systems, was what they believed would prevent any one segment of government becoming too powerful and restricting our rights and liberties. Also, it also could develop into more of a tyrannical form of government, even if it might have been efficient. They did not want to end up with kind of an overreaching parliament, what the Congress would be, but they also did not want the king to have a king who could have such extreme powers that King George had during the Revolution and before the Revolution. So you have their major focus being on the Congress, quite a few provisions in there. And what I want you to really pay attention to on this is, besides looking at these powers, which for the federal government, which for the national government, these are very much, these are expressly granted powers. These are not saying that you don't have these powers. They're saying these are the powers that you have, the enumerated powers. But there is a very important provision, and it's in Section 8. Now, Section 8 out of Article 1 is something you should be very familiar with for this course. And it gives you the enumerated powers of the Congress. And there is a portion of this, which is actually Section 8, and that is often called the necessary and proper clause, often called the elastic clause. It's to make all laws which shall be necessary and proper for carrying into execution the foregoing powers and all other powers vested by this Constitution in the government of the United States or any department or officer thereof. This provision allows the federal government, in carrying out its expressly delegated powers, to make or create or pass other laws which the Congress deems necessary to carry out their expressly granted laws. This particular provision is at the root of a lot of the conflict between state powers and national powers. The ability of the federal government to pass laws that, in carrying out their expressly granted laws, that often, in the viewpoint of state governments, impinge upon their specific responsibilities. And the Supreme Court is the arbiter of this particular issue, whether or not one of these powers that the Congress has assumed and passed a law for to help them carry out their express duties, whether that particular provision, that law, has actually infringed upon the rights under our system of federalism of state governments. Probably one of the more prominent examples of this at this current time is we start talking about gun regulation of firearms. At one point, the U.S. Congress had passed a law that required the state officers, like the sheriffs, to help in enforcing the background regulations of an act that the Congress had passed to regulate firearms. And this was in regard to background investigations. And the Supreme Court and the states objected to this under Federalist grounds, and this was a violation of federalism and their own sovereignty. And the Supreme Court decided that, actually reached a decision that this was an overreaching on the part of the government, and they were infringing upon the sovereignty of the state governments by requiring them to actually work, in effect, under the orders of the federal government. And this actually affects us even today under firearms regulations, because when the states, in regard to background investigations, state governments really are not required under law to help enforce the federal regulations in regard to firearms. For example, we want information from states regarding individuals who've been adjudicated insane, or have been adjudicated as mentally ill, or have been found, or have been committed, involuntarily committed to an institution. The states are not required to turn that information over to the national government. They have to voluntarily do that. They can't be ordered to do that. And that's an example of how this principle of federalism works in an issue today that's very prominent today. Now, look at Article 2, and Article 2, we're dealing with the presidency. And a couple things to point out about the presidency's powers here is that for all the powers of the presidency, the two major issues, the two major areas in which the president really is supreme is as commander-in-chief and in the execution of the laws passed by the Congress. If his commander-in-chief duties, where he's controlling the military, making decisions, although his powers are very powerful in that regard and have really relatively little, there's relatively little that the Congress can do as far as imposing or intruding into that area. The other areas when how he executes the laws. Now they have oversight. There are things in which the Congress can do, but the presidency has a great deal of power in those two areas. Now, for many other areas, like executing treaties, signing treaties, I mean, not executing, but signing treaties, for example, selecting his cabinet, selecting appointing Supreme Court justices. In many of these, what we would consider relatively traditional things that a president does, the president has to work with the Congress in getting these things done. The typical term is advice and consent. He needs the advice and consent of the Congress to do certain things. He can appoint a justice with the advice and consent. So we do see this. There is this checks and balances on the powers. And for another example of a check and balance, yes, the Congress has total power to pass laws, but the president, as a check on their power, our founders thought that there should be some check the president can veto. That is a check. But that's balanced by the Congress's ability to override the veto of two-thirds with a two-thirds agreement in both houses of Congress. So you see these checks and balances at play all the time. The Article 3 deals with the powers of the Supreme Court, and that's the shortest section. And at the time the Constitution was drafted, the drafters clearly did not foresee the extent to which the Supreme Court today is such an integral and powerful part of our tripartite system of government. They clearly didn't envision that the Supreme Court would ever be involved in finding state laws unconstitutional and ensuring that those, in fact, once that's been done, ensuring that those laws could not be implemented. That was just something that they didn't feel would be a factor. They saw the Supreme Court as being solely restricted to resolving issues involving just the federal government. We see that change after the Civil War, where they passed the 14th Amendment, which basically changed the whole trajectory of the interaction of the Supreme Court into the overall discourse of U.S. life today. So what we have are the main three articles, and I'll point out for you also, they'll be familiar with all the articles. Article 6, very important article, Section 2, this Constitution and the laws of the United States, which shall be made in pursuance thereof, and all treaties of the United, under the authority of the U.S., shall be the supreme law of the land, and the judges in every state shall be bound thereby. Anything in the Constitution or laws of any state to the contrary notwithstanding. So, yes, we do have dual sovereignty to a degree, but the Constitution, the national governments, the federal Constitution is the supreme law of the land. And that is certainly evidence that in regard to violations of the Constitution, as perceived by the U.S. Supreme Court, that law is the controlling law of the land. Although states have challenged it, but always unsuccessfully. And I will say Article 7, which is basically the ratification process, which, another article too, the, let's see, Article 5 is our amendment article. The drafters knew that it could be necessary to formulate amendments to the main body of the Constitution. In fact, they saw that coming down the line within a year or two, because one way they were able to get the Constitution ratified was by basically assuring some of the more recalcitrant states that they would pass a subsequent Bill of Rights that would amend this Constitution. So they put a process in effect here for amending it, and they don't make it easy. It's a rigorous process. Be familiar with that. It means that we don't have a lot of amendments, that our Constitution has remained fairly intact, and the amendments that we have had usually, in some cases, are controversial. Most of the times, by the time they're ready, the country has moved in a certain direction where it was that they believed that the people believed that there was enough pressure, on the Congress, and they are the initiators of the amendment process. There was enough pressure on them to actually amend the Constitution in certain areas. A simple example of that was to amend it to allow voters to be 18, to change the voting age down to 18. The amendments, again, different provisions. We'll be looking at those later this week when we talk about the First Amendment. Okay. Let me get my notes here and make sure that I'm hitting some of the key points for you. A little break from this. Let's go back to your outline, though. Make sure we understand a few things about this outline. Do not neglect to read it thoroughly. We'll look at the course requirements. 2 exams. They'll be on Blackboard. 30% for the midterm, 50% final exam. Now, the 2 other major grading elements of this course are that the 3 briefs that you'll be required to do, and there will be a short report on a current significant issue involving constitutional law. Both the briefs and the report are 10% each of your grade. So you've got the 2 exams, and you have the report, the written report, and the written briefs. Now, you're also expected to participate in a discussion forum. You'll see that on Blackboard. This discussion forum is really for you guys. I expect you to get on there, discuss issues in the cases we're talking about, the major issues of our times, and that's what the Supreme Court handles. Not always, but a great majority of their time is remember, they're a discretionary court. They don't have to hear cases. They decide what cases that they should hear and decide on. And that means they often take some very, very controversial and important issues to the United States. So they should be something that you should be engaged with one another on. Now, what I will do, I won't be a participant in the discussion board, but what I will be doing in the assignment section is on certain weeks I will assign an issue that I want you to discuss in the discussion board. And you can bet that'll be a controversial issue, one that there's 2 sides, and both sides might commonly feel they're right, and in some cases we might have an issue that I'd like you to discuss in which the country is heavily divided on. So I'm looking at that. Now, if you do that, if you participate fully, and I want a minimum of 2, maximum of 4, that means 4 really participations in 1 week's time. Each week, each week of discussion, I'd like to see you on there at least 4 times, and I want a valuable, I explain this as basically a valuable class participation. That's what I'm looking for. Some real comments, some real original thought, not just saying, oh yeah, I like your idea, or yeah, that's great, or I disagree on that. I want thorough answers or thorough questions and a thorough discussion. I'd like to see 4 of those contacts to to get a reward, and that means a bump up in your grade will be a bump, 1 grade indicator. 2's a minimum. It means you don't get hurt. You participate less than 2, or you participate twice, but it's not valuable. You're just in there checking in. Your grade gets knocked down 1 indicator. So I think the discussion forum should be important. And I'd like to see the exchange with your peers, how well you reason, either apart and sometimes reason together. And like I said, I will guide this in certain instances, but I also expect some self-generated issues that you yourself want to raise with one another. There's also a short forum there where you introduce yourselves to one another. I think that helps in these courses. The briefs and the paper will be graded by the use of a rubric, which will also be in your documents section. I also have some reading assignments apart from the book, not maybe 1 or 2, apart from the cases that I want you to be briefing. They will all be found in the documents section, either downloaded or there will be a link to the case or the readings, or a website that I want you to look at, or to, in some cases, listen to aid your discussions on the discussion forum, in the discussion forums. All right. The grading system is on page 3. We're going on percentages: 100%, report 10, briefing 10, final exam 50, and midterm 30. The policies are in here. Again, read the policies. If you're going to withdraw from this course, I would contact the registrar's office to find out how quickly that has to be done, so that you can get out with just a W, and also when you can withdraw without making a payment. Check closely the academic integrity section on this. And I want to caution you about the brief